Not a... So tonight we've got an incredibly special guest joining us, and we've got Chief Justice Lucy McCallum joining us, and I'll get Justice McCallum to introduce herself first of all. Thank you.
Hello, everybody. Yeah, I'm Chief Justice McCallum. I've just started at the ACT Supreme Court in March of this year. Before that, I was on the Court of Appeal in New South Wales for 3 years, and before that, I was a first instance judge in the New South Wales Supreme Court for 11 years. And before that, I was a barrister for nearly 18 years. And before that, I was a solicitor for about 18 months. And before that, I was where you guys are now as a law student and a barmaid. So
fantastic. So you were like many of us, you did another type of job like that whilst at university. Did you find that that was sort of useful?
Oh, absolutely. Yeah. Absolutely. I actually once, this is how old I am, before the internet, they used to have a barrister's directory, which was a printed like booklet, and you had to fill in previous occupations, and I filled in barmaid, and I got a call one day from a solicitor who said, "Lucy McCallum, did you really used to be a barmaid?" And I said, "Yep." And he said, "All right, I've got a brief for you." I said, "Does it have anything to do with being a barmaid?" And he said, "Nope, I just think that way you'll just know a lot about life if you've been a barmaid." So I know I got at least one brief out of that.
Oh, that's fantastic. And I mean, a lot of the UNE law students as well, they're doing other jobs. A lot of them are mature aged, and then they're segueing into law. So that's fantastic, you know, feedback and advice for them that is, those sorts of jobs and any other kind of jobs are useful to the profession as well.
Well, I think that the broad is that life experience is not more important than academic ability, but it's certainly a boon to being a good lawyer.
Fantastic. That's really good to hear. Thank you, Judge. So first question, and as I indicated to you before, I had a couple of students who specifically wanted to ask you a couple of questions. So we'll start with a couple of questions relating to defamation. So the first question, and this is from Mandy, a student in the unit, asks, do you think the law has kept up with the development of social media? And if you don't, do you have any suggestions on how this could be achieved?
Well, the short answer is no. I don't think it has kept up. But I need to answer the question by reference to the two different sources of law, the common law and statutory law. And if I could kind of explain that by way of sort of prefatory remark, when I was studying law, I think the common law was the main focus of the development of the law. And if you read the cases and stayed on top of the cases, you could be reasonably confident that you knew the law. And every now and then someone might come along and suggest there was some pesky statute that intruded in that field. I think fast forward sort of 30 or so years, we now find that there is a huge proliferation of statute law. And one message I would say off the topic of this evening, but just as a general thing for law students, is you need to get across statutory interpretation. I thought it was a kind of a sideline when I was a law student, but increasingly every day it's part of my work. And you need to understand how the statute gets brought to the common law. So you need to understand the common law history, the development of the cases through the decisions of the judges, but then you also need to read a statute that comes into that area against that background. I love statutory interpretation, but I also think it's become a very essential skill for young lawyers. So the common law has been grappling, and the second question which you've sent me in advance is a really astute question on this topic, but the common law has been grappling with this issue of what is a publication, when is a publisher liable. In the olden days we used to say, well, if you published a book or a newspaper or put a notice up on a notice board, that was a publication. But now we have to deal with what if it's a Google search, that you've put in your own name into a Google search and it brings up Lucy McCallum fraudster, or a Google search with an embedded link, or as in Vola, a news story with comments on a website. We really have not been able to keep up with those developments, because you can only develop the law in the common law as cases come up that flick up those questions. But in the meantime, there's a lot of reform going on in the statutory field. I think your students might know that there's uniform defamation law across Australia, been enacted in the states and the territories, and there's been a fairly lengthy process of reform, of working up to those reforms, which the New South Wales Attorney General has had stewardship of, but it's common across all the Attorneys General, and that legislation has now come into force, and they've tried to kind of regularise this issue of publication. What is a publication? And in the second phase of the reforms, which haven't yet gone through, they'll be dealing in more detail with social media publications. Any student who's interested in learning more about this can go on to, I think, probably on the New South Wales Government website. I think they have all the discussion papers, which have a great deal of information about how we deal with social media publications, but it's really complex. Every case I did when I was the defamation list judge that introduced social media publications threw up some other complex issue about publication. And we think we know a publication is when information is conveyed from a publisher to an audience, and you think, well, that's easy. You pass a letter to someone, you open a book, you read a newspaper, you listen to the radio. But once you start getting all those issues of a link embedded in a search result or a snippet and those sorts of questions, it does become more complex, and I don't think the common law has kept up. There's the recent decision of the High Court in Defteros, which I hope you haven't made your students answer an exam question, what's the ratio of that decision? Because I don't think there is one. Who got multiple judgments with very different approaches, and that's, to me, that's not helpful to students. The High Court has
incredibly difficult.
Yeah. There are 7 of them, and if they don't agree, they don't agree. But I think a judgment on such an important issue that has 4 different approaches to the analysis of the question, is the defendant a publisher, is not helpful to students, practitioners, or clients. So,
no.
Long answer to a question to which the short answer is no.
No, we haven't. Okay, thank you very much for that. And certainly it's really lovely to hear. Often I will have students say, I really don't understand this, and I said, but have a look at a particular High Court case, and it doesn't look like they can agree either on the principles. So you're in good company.
Well, again, as a side comment, that's actually probably a really important message for your students, and to know. I have a good friend who's a bit of a law nerd like me, and we have evening meetings. Yeah, she's in Sydney, but we have evening sort of Zoom meetings or telephone conversations where we're trying to work out what a recent High Court decision means. So your students should not feel any embarrassment about reading a decision of the High Court and thinking, okay, I still don't know what the answer is. And I guess that's the skill to develop, is read all the documents and try and track them and work out what footprints are being put in the sand and where this area of the law is headed. But you shouldn't feel embarrassed or any kind of anxiety at all about reading a High Court decision carefully and still feeling that you're not quite sure what the law is on that topic or what the ratio is. That's the way the common law developed. That's its beauty and its complexity, but it's also the burden of the law student.
That's right. Okay, so the next question I wanted to ask you, again from another student in the unit, Nikki, is, do you think the Vola decision, in terms of social media page owners, essentially being the publishers of third-party comments, would have impacts in other areas of law? For example, if a news outlet posts a story about COVID and a third party uses the comment section to promote their ivermectin shop, could the news outlet be in trouble with the TGA for restricted advertising rules? Very simple question there.
Yes. My first answer to this question is, Nikki, you're going to be a great lawyer. It's a really good question, because what you've done is draw together well, you've drawn sort of from one area of the law and thought, how's that going to apply in different contexts? And I just was blown away by this question.
You've got good students at UNE Law, there's no doubt about that. Yeah.
I'm getting that. But I think, I think the answer is yes. I think it could have that implication if some bright young thing from UNE picked it up and argued it. And the reason is because that's the way the common law develops. For example, in the field of misrepresentation, it's fairly well established in New South Wales that the principles relating to publication in defamation carry over by analogy to making a misrepresentation. So if you've published a defamatory article that conveys a particular meaning, you've also made a misrepresentation if it's false. So I just love the way that the person who's posed this question has kind of thought outside the box and gone, well, hang on, what about misleading advertising? Could that work the same way? And the answer is I'm not aware of any case that says that, but it's a beautiful example of legal reasoning by precedent, but precedent, stretching the precedent outside its area and thinking, well, could that apply in a different field? And there's a whole bunch of cases about coherence in the law, that the law should be coherent across disciplines. So the answer is, I guess, why not? But I'm not aware of any authority, but it's a terrific argument.
Fantastic. I'll make sure, Nikki, I can imagine, will be incredibly chuffed with your feedback. So thank you. So now we've talked a little bit about defamation. We're going to segue now into looking at social media and litigation, which is another area that we're looking at in this particular unit. So these are just sort of some questions that I came up with. So they're probably not as insightful as Nikki's, but that's okay. So, and I've just, again, your sort of thoughts. So as I indicated, I recently read an article, but it was from an American context, because I'm finding a lot of the literature is in relation to social media is from an American context. So as I said, I recently read an article about legal practitioners using social media to advocate or broadcast their legal arguments on behalf of their clients in high-profile litigation cases. And do you think that this is, or potentially if it's not, it should be happening in Australia? Have you noticed anything in this regard?
The answer to that question is, I hope it isn't and it shouldn't be. A fairly fundamental difference between Australia and America, which I hope is always preserved, which a long time ago, when I was a barrister, I don't know if you said you had to have some mature age students, so they might have heard of O.J. Simpson.
Majority of the students at UNE are mature age. So your typical UNE student, law student, would be a female, 34, and probably 2 kids. That's your typical demographic. Yeah.
Also, I may or may not have heard of O.J. Simpson, but he was charged with murdering his wife, and then he got acquitted, and then he got sued by the family on the basis that he was the person who was guilty of the murder. But the point is that during his trial, his criminal trial, one of his team of barristers, who's a very famous New York barrister, came out to Australia to talk to Australian barristers, and I went to the talk. And he said, there are 2 things about the Australian legal system which I just love and which we don't have and which I hope you never give up. And one was that he said, in America, if I'm not fighting the case in the press as well as in the courtroom, I'm not serving my client. Whereas in Australia, because of our laws of contempt, it's not acceptable to fight the case in the media. You fight the case in the courtroom, yeah. Case in the media. And I don't know whether I'm not saying anything that isn't a matter of public record here, but I was due to hear the sexual assault trial of Brittany Higgins, and there was a lot of media publicity around that case, and the barristers for the accused made an application for a stay based on media publicity, and initially I said no, and then about a week before the trial, there was another huge splash of media because a journalist had won an award about her story about Brittany Higgins, and it just went crazy. And I just went, okay, this guy cannot get a fair trial next week. So I did stay the trial until October, and it's coming up in October. But the point that in Australia we regard the discussion of the legal of the case in the press as a bad thing, because it might fetter the impartiality of potential jurors, whereas in America they've just kind of owned that as a, sure, we should know everything, and they vet their jurors for, what have you read in the press? We don't vet our jurors. We have, a jury panel where we impanel the jury. We know nothing about the jury, and the only basis that the criminal lawyers have for objecting to a potential juror when their number gets called and they get called up is that is just on appearance, which is pretty blunt tool for assessing a potential.
That's right.
Yeah, so, and the second thing he said that he loved about the Australian system, which he hoped we would never lose, is elected judges. So, and we have judges appointed by government. America, in some states, the state judges are elected. And even you will have seen recently with the Supreme Court, they're not elected, but it's a very political appointment. So I think those are very two fortunate aspects of our system. But the short answer to your question is I don't think barristers should be spruiking their arguments in the press and sort of effectively trying to influence, sort of making them social influencers. They should be advocates in court trying to persuade the tribunal that's going to decide the case, whether it be the judge or the jury.
Fantastic. Thank you, Judge. So next question, do you think, another thing that I've been reading a lot about as well, do you think social media is an appropriate tool for both service and discovery?
I'm going to say, Julia, this is a great question. You're right up there with Nikki. It's an awesome.
I was going to give Nikki my job. So thank you.
Well, I mentioned to you in one of our discussions, the reason I sort of postponed this from last week to this week was this morning I participated in, I'm a member of an expert panel for the law reforms I was talking about. So I knew I'd be much more across it today than I was last week. But one of the potential reforms is a question of currently, before you commence proceedings for defamation, you have to serve a concerns notice, and currently there's you have to do that in the more or less traditional way, but you can do it by email, but only if the person has confirmed that that's their email address. And some of the people on the expert panel were saying it should be broader. It should be, you should be able to tweet it or put it on Facebook. And the sort of like the judges and the sort of more senior lawyers, and including myself, were saying, no, that's really not a good idea to allow service by social media. And I was sitting there wondering whether that just reflected our age and the fact that we're not up with social media, or I worry about the idea of someone resting on someone using social media to learn an important legal step against them. But then I thought, well, by the same token, I know the reason I often don't know what my kids are doing is because I'm not on Facebook. So it's a really good question. I think for me, I would adhere to the conservative approach of you've just got to know that someone is definitely going to see something in order to use that for service. But maybe I'm outdated in considering social media to be included in that. For discovery, I think it's actually not a bad idea, except, I don't know quite how it would work. I guess what my answer to your question is, I'm probably showing my own sort of lack of development with social media by the answers.
Not at all, no.
Yeah.
But interesting. It'd be interesting to see in 10 years' time where we'll be at, whether or not these will all just be no-brainer sort of questions, it'd be fascinating. So next question that relates to that as well. From your experience, are social media posts and content increasingly being used as evidence in litigation?
Now, I have to say, in civil litigation, not that I've noticed, but that might just reflect my more recent experience. But I will say that in criminal proceedings, people who are accused of criminal offences are hanging themselves with their social media. It's just unbelievable what they will post and what they don't realise it will, the implications they don't realise it will have for them. The police have become extremely sophisticated at following social media communications. So photographs that get posted on Facebook, I think a lot of people don't realise the photograph has embedded information about when and where the photograph was taken. So you get gangsters, sort of posting photos of themselves with a cash and on Facebook, and you go, oh, here you go, right there in the bottom of the screen. They were in Liverpool on the 7th of May last year. That happens to be where the bank got robbed. So I would just say in the criminal context, people are implicating themselves in ways they don't understand because they don't understand how advanced the technology can be. Right. But I haven't seen it so much in civil cases, except I know there was one. Oh, no, sorry, it was a criminal case, a case where someone got prosecuted for making a threat, like a stalking kind of offence, where they'd sent someone a text message which had 3 emojis, which was an open mouth, an ambulance, an open mouth, a knife, an ambulance and a hospital. And that was construed to be a threat. So.
Oh, wow, because that's one of the things that's been recently talked about, isn't it? Emojis and, what the implications are of emojis. So.
Well, I think it comes back to Nikki's question, the corollary. If you can convey a threat or a misrepresentation or defamatory imputation by a gesture or a facial expression or, pointing at something, then you can certainly convey it by emojis.
Emoji as well. Fantastic. I have to watch the emojis that we're using as well. So from your perspective, do you think that there are significant problems with using social media content as evidence?
I mean, I guess it depends what kind of evidence you're wanting to use it as. But the short answer is no. I don't see any reason why that material can't be very informative. It is the way people communicate. I don't see any reason why you can't regard it as the same as, if you want to talk about it as evidence of an admission or where relevant evidence is the fact that the words were said or the fact that the information was communicated, it's no different from a person giving evidence of a conversation they overheard or a conversation they participated in. So I don't see any difficulty with that at all, really.
Okay, fantastic. So how do you think privacy considerations come into play in relation to using social media content as evidence?
Well, I think privacy is something that our common law has never really grappled with very well. One of the things I'm finding really interesting, having moved to the ACT, is that the ACT has a Human Rights Act, and so there's a potential for greater protection of privacy and reputation, one of the rights identified in the Act. So I don't really yet know how that would play out, but the court has never been very good at respecting privacy. So if something that is relevant and admissible is contained in a social media post, it's going to go into evidence, and there's probably not going to be much protection for the person whose privacy is interfered with by that. I guess one countermeasure to that is that we do have reasonably robust laws about non-publication orders, which are intended to protect people. And I've always thought one of the it's interesting that the most fertile field for non-publication orders is child sexual assault, because you don't want to identify the child, and very often identification of the adult identifies the child. So all the child sexual assault accused persons get the benefit of non-publication orders for the protection of the child, and a lot of that is social media evidence. But in a civil context, I think there's going to be very little protection unless involves non-publication orders, which courts are reluctant to make because of the golden principle being transparent, open justice. And the law has always assumed that damage to reputation or invasion of privacy is just part of justice. And unfortunately, I think like many areas with social media in the courts, that is now seeing a greater intrusion on justice, and we're not really addressing that.
Okay, interesting. Thank you. So, final question. Are there any examples where evidence gathered from social media sites cannot be used in litigation?
I tried to think of an example and I couldn't. I mean, ultimately, the question for admissible evidence is if it's relevant and, you know, if it's relevant to the issues in the case. And I can't think of a reason why the fact that it's sourced from social media would make it inadmissible unless it went to reliability. I mean, I guess you've just got to think about how would it be admissible. If you're talking about a case where it was, I suppose, a criminal case, if it's a threat, well, it's there on social media as it would be there if it was in person. If it's relied upon for the truth of what's contained in the social media post, it would be inadmissible, just as any hearsay would be inadmissible. So I couldn't really think of an example of
one of the things they talk about in the text relates to, let's say, give an example where a legal practitioner actually created a fake social media profile and then they tried to befriend one of the opposing parties from the opposing side to gather evidence.
Wow.
And harvest evidence. So that was one of the things that was actually mentioned in the text that the students are reading.
That's a really good example because that's invoking the principles of evidence that's unfairly obtained. Yeah, so yeah, that's. But you know, again, to extend the idea, I think I've been trying to convey that really, the fact that it's social media is no different from the olden days. Is the Paul Newman film, The Verdict, which all your students should watch. It's compulsory watching.
Absolutely.
Got her name, that beautiful actress, is exactly that. She's befriending Paul Newman, trying to find out information about how he's running his case. But yeah, in that situation, it's not the fact that it's social media that makes it inadmissible. The fact that it's unfairly obtained, or you know, is likely to cause prejudice, or prejudicial value might outweigh the probative value. Prejudicial effect might outweigh the probative value. So I don't think the fact that it's social media actually comes into that analysis.
Interesting. Well, sorry.
Couldn't sort of, if you couldn't source it, like if the fact that it was social media meant you couldn't work out where it was from, or it's that might be a consideration. But
one of the other things they talk about in the text a lot about identification, and that can be a problem as well as identifying.
Yes.
Who, just to verify, of course, because But really,
I don't know that people who caught up on the fact that it's social media. It really just, and that's the same thing that applies throughout the law. Is if you understand the basic principles, just apply them to a new factual scenario. Take Nikki's question. You apply the vola principle to a different area of the law. And that's a mistake a lot of lawyers make, is that they think that a factual case is authority for the result in another factual case, but that's not the way the law works. The task is to distill the legal principle and then to apply it to a different factual circumstance.
So this is just something that I just thought of then, Judge. Did you ever think that when you were a law student 5 years ago, that you would now be sitting here as the Chief Justice of the ACT? Did you ever think that was going to happen? What would you have thought if you'd known in your first year as a law student?
I wouldn't have believed it if you told me. I feel incredibly fortunate to have had the opportunities I've had. I think I think I will say, you know, for the comfort of your students, although it might not be very comforting, but I feel as though I've been very fortunate in my timing, because I've sort of come through at a time when it wasn't no longer the case that people were trying to exclude women, and they were kind of looking to include, but there weren't many women coming through. So I've been very fortunate. But for the 30-somethings with 2 children, I will say, based on my experience, that it's a lot more achievable than you think it might be to have a career and also look after children. And actually, I'll tell you a story. We had last Friday, we had an admission ceremony for new lawyers, for 40 new lawyers, and the registrar got an email at like 3 o'clock in the morning the night before from this poor woman saying, my child has just been airlifted to Sydney Children's Hospital. She's very unwell. Could I possibly dial in to the admission ceremony? And I said, oh, for goodness sakes, just tell her we'll give her, you know, we'll admit her separately when this disaster's all over. So this Friday we just had a bespoke admission ceremony for this poor woman whose child was by then out of hospital and in court, sort of fussing around in her pretty little pink frock. And so I got the whole court. So that in Canberra there's six of us, 6 judges. So I got the whole court to sit for this admission ceremony for this woman. But I think my point is that I think more women are coming through who are parents and carers and understand the balancing. So it's very achievable to be a good lawyer and a good parent, I think, in this day.
Thank goodness for that. And it'll be interesting. Do you think, and this is, I promise you the last question, do you think that now that we've got a lot more female lawyers as well, that is changing potentially the law and the way the law is developing?
Absolutely. And I'll give an example of an area where I see that is that I've just, I won't give details, obviously, about a case that I haven't decided, but in the field of child sexual assault, if you go back to the old cases, a lot of the reasoning about what is adequate evidence, I read them now, and it's like reading a novel written by an old white man 50 years ago. You pick it up and you read it and you go, nobody thinks like that anymore. And I think the having more and more women as prosecutors, as public defenders and as judges is changing the way we analyse evidence, because I do think, well, I won't just say just women, but I think having a more diverse legal community has changed the way people analyse evidence and facts. And it's not that, you know, diversity is a strength. It's just in an ecosystem, you have to have biodiversity. In a legal system, you have to have diversity. If you have a mix of women and people from different cultures, people from different socioeconomic backgrounds, it changes the way we analyse factual questions and legal questions. So, yeah, I definitely think the numbers of women coming through are changing things for the better.
Fantastic. Thank you so much, Judge, for that incredibly insightful and interesting discussion tonight. I'm so excited that I've been able to speak with you, and that my students are going to have the ability to listen to your amazing insights and analysis.
Thank you.
Thank you so much.
I enjoyed it, Julia. I love the idea of being able to communicate with people who are coming through the system and hoping to imbue them with a bit of excitement and optimism about what's ahead of them, because I've had a great time, and I hope that's opportunities available for other people too. So,
well, you've certainly inspired me, and no doubt all of the students. So thank you again, Judge.
Thanks, Julia. See you.